3, 2, 1, start. Mr. Mukherjee, learned public prosecutor, opposes the petitioner's prayer, drawing our attention to the statements recorded by the witnesses, including the doctors, and submits that the couple was having a strained relationship which affected the victim's state of mind, and she could not overcome the consequential depression and trauma in spite of her best endeavor, and in view thereof, the link between such matrimonial discord and her sudden death cannot be ruled out. Stop para. He argues that many witnesses, including Vikas Yadav, a driver, and Sagar Munda, a cook, are the employees of the petitioner, and there is very possibility that they would be tactically groomed and pressurized by him and his family members to give statements in their favor. Stop para. He argues that investigation is still in progress and grant of any protection against custodial interrogation would render questioning the suspect, being the petitioner hearing, to be a mere ritual. Stop. The answers given by the petitioner in course of interrogation on 17 November, 2021, 23rd November, 2021 and 29 December would reveal his known cooperation with the investigation. Stop para. Mr. Kollan Bandyopadhyay, learned advocate appearing for the de facto complainant, submits that on 16 February, 2021, the de facto complainant's daughter expired and he was not in a position to comprehend and narrate all the facts and incidents in a nutshell on 17 February, 2021, and as such a further representation was submitted on 25th February, 2021, detailing all the facts pertaining to dowry demand and other instances of cruelty and harassment. Stop. Non-incorporation of the details in the initial complaint dated 17 February, 2021 cannot be construed to be any flaw, more so when, FIR is not meant to be an encyclopedia nor is expected to contain all the details. Stop. In support of such contention, reliance has been placed upon a judgment delivered in the case of VK Mishra versus State of Uttarakhand, reported in 2015 9 SCC 588. Stop. According to him, the investigation had been conducted in a perfunctory manner. Stop. Immediate steps were not taken by the investigating officer within insert, IO to recover all incriminating materials. Stop. Placing reliance upon judgments delivered in the cases of State of Rajasthan versus Jagguram, reported in 2008 12 SCC 51, Dr. Naresh Kumar Bangla versus Anita Agarwal and others, reported in 2020 SCC online SC 1031, and some WhatsApp messages, he submits that the victim had always been taunted and mentally tortured by her husband and her other in-laws, for which she was depressed and was instigated to commit suicide. Stop. The petitioner is a drug addict and he always used to communicate with his ex-girlfriend, stating that he was forced to marry the victim. Stop. The death occurred otherwise than under normal circumstances, and as such the ingredients of section 304B are clearly attracted. Stop. Grant of anticipatory bail in such a serious offence would operate to obstruct the investigation. Stop. In support of such contention, reliance has been placed upon a judgment delivered in the case of Dr. Naresh Kumar Bangla versus Anita Agarwal and others, reported in 2020 SCC online SC 1031. Stop para. He submits that though the warrant of arrest was issued on 17 April, 2021, no steps were taken by the IO to arrest the petitioner, and thereafter on the basis of the observations made by a coordinate bench of this court on 8 November, 2021, the warrant was recalled on 10 November, 2021. Stop. A party cannot be allowed to take advantage on the basis of such act of the court. Stop. In support of such contention, reliance has been placed upon the judgments delivered in the cases of Cantonment Board versus KP Singh, reported in 2010 2 SCC 518, Kala Bharti Advertising versus Hemant Vimalnath Nari Chania, reported in 2010 9 SCC 437, Prasanna Kumar Roy Kormokar versus State of West Bengal and others, reported in 1996 3 SCC 403. Stop para. He submits that the petitioner, whilst influence upon the witnesses, as would be explicit from the report of the IO dated 15th August 2021, wherein it has entirely been stated that the witnesses, who were employees of the petitioner, were being tactically groomed and pressurized by the accused family to give statements in their favor. Stop.